Welcome everyone. Today I have a special guest, Benjamin Delsol. He's quite known for all of his nice and beautifully written newsletters, The Art of Strategy. And he has very nice story. He was a scientist with PhD in quantum physics and then transiting to be a patent attorney and of course IP strategist. Welcome, Benjamin.
Thank you very much. It's very nice to be here. It's a great pleasure. I have seen your podcast so many times, so to be here, it's great. Thank you very much.
Yeah, yeah, thanks. That's a great honor to hear you. Actually, made quite interesting leap in your career from being a scientist, graduating from science and quantum physics. In particular, your PhD was in quantum nanoelectronics and the material sciences. However, you made a leap from this field, from quantum physics, from nanomaterials, nanoelectronics, to being a patent attorney and IP strategist. What inspired you to make this a change in your career?
Yes, and if I tell you why I wanted to have this PhD, you will be even more asking why. Because when I was when I was 10, I wanted to get a PhD in quantum physics already, you see? So I worked for that and I get it. And I changed.
Nice.
I changed because I love quantum physics. I love science. I love research, but I don't really like administration stuff. And I've seen that when you are working in a lab, you start very motivated and so on. And when you see during the years how many paper stuff you have to do just to be able to make this project or to get money for this project and so on, it was not really science for me. You see, I'm like a kid. I wanted to play. I wanted to play science and quantum physics and so on. So for me, it was not enough in a way. And I don't like to do always the same thing. So I was thinking, what could I do? And of course, because since I was 10, I was into physics. And even before at 9, I wanted to be an astrophysicist, but I changed.
Nice.
So I was aware of Albert Einstein, of course, and work, but also life. And I know he has worked in Bern, in Switzerland, in a patent office. So as a child, I was kind of always aware of the patent office and more or less what is a patent, or at least an invention can be protected. That's it. So when I decided to change, I had already a great taste for law, a great taste for business and innovation, of course. So I said, let's give it a try. So I changed. I just sent my resumes to several IP law firms and also companies that was looking for a patent attorney or trainee patent attorney at this time. And I get a position actually I get two positions, one in Belgium and in a company, and one in Nice, south of France, in an IP law firm, private practice. So, okay, for the weather, nice, of course, Nice was better. But yes, also indeed. For the position, private practice, I was thinking, I will have several clients, not always the same tech. So it will be very good to be on the field and to learn IP. I think it's the best way to do it. So I decided to go in this IP law firm. It was a perfect choice. I met two incredible mentors with a very strategic vision of IP. One of them had an MBA, so he has very strategic and business way to think about IP. So of course I learned IP like that. So it was a perfect fit for me, which I always think about strategy in every part of my life. So learning IP in a strategic way was perfect for me. So I spent 7 years there, and then I have been asked to move in Switzerland by a company. So I was 7 years in private practice. I said, it's good time to change, to go into an international company and to see what looks like from the inside. So I spent 2 years there. It was very interesting from the business point of view. Because of course you understand how IP works within the company, within all the different operations of the company, what are the main issues and also the solution to bring and so on. And then I decided to create my own company because I have my own way to think and to do IP. For me, it's simple. There is no business without innovation, no innovation without IP, and no IP without business. So all the three works together. So I decided, to create my own company. And as soon as I created it, I've been contacted by several IP law firms across the world that asking me to work for them as a consultant. And they bring me clients, and they have also clients in direct. And I mean, everything fine. It's amazing, but it works. Yes, yeah.
Yeah, that's really great to hear, and this is a very amazing story. And you mentioned that Albert Einstein already worked in a patent office, and I feel like this is also quite like, for example, forgotten in the history that that started early on, that physicists and also people with academic degrees can work in a patent office to help patenting
exactly.
innovation.
Yeah, because we need, as a patent attorney or even as a patent examiner in a patent office, you need to understand the technology. So you need two things. You need to understand the tech, but you need also to be able to make research, read a lot of papers, to be able to assess the novelty and the inventiveness of the patent application, of the invention. So basically, this is what you do during a PhD. you read a lot, and you write, and you understand technologies, and you understand science. So more or less, it's very related. And it's a good fit. But I would say that things are changing right now because of AI, for example, which is coming now. It's changing the way we work as patent attorney. I mean, we see more and more solution to draft patent application with AI. So at one point, a patent attorney must evolve and become a business partner. Not only a patent attorney to draft a patent application, but really a business partner. So this is what I do from the day one. It's to use IP as a weapon of mass construction for the business of my clients. So it's more about business also, law and innovation and technologies, but not only about technology and law. You need to bring the business part.
Yeah, so it's about creating like business partnership, and the strategic partnership as well, in that not only to file a patent to get some number in WTO or anything.
Yeah, exactly. For the two sides, I mean, a company wants sometimes to just get a lot of patent application. Why? Just for the numbers, or just because the inventors are happy when they file a patent application. And so it's not a strategy. At least it's a bad one, I would say. And the patent attorney, in a way, is paid for drafting. So please give me invention to draft, and I will be happy. So the strategy part is only if you care about your client, if you care about the future of your client, if you don't want him to burn cash. You see, so you will have to say. Sometimes I say to my clients, no, I don't think it's a good idea to file this patent, or to draft at least a patent application for this invention. It's better to keep it secret, for example, as a trade secret, or sometimes it's put it on an open source. And I think you want to talk about that. But there is so many things that you can do with IP beyond just filing patent application.
Yeah, that's very interesting, especially this point about don't file the patent just to keep it secret. Because everyone, I feel like they rush quickly to file a patent because they are in a marathon of patents, but then they might lose this advantage opportunity that they have by releasing the information to the patent database.
Honestly, what I like to do, it's both. I like to file a patent application, but keeping some part secret. So that means the patent will describe perfectly the invention, but it will not work as good, as well as your own product. So that means that the competitor will be able to know everything about how it works. But even if you try to do it the same in jurisdiction where you are not protected, for example, it will not get the same product as good as the one you are manufacturing and selling, because you keep some part as a secret.
Remember, you gave a presentation about this, and you are calling it keeping the secret ingredient, this
Yes,
wow
exactly.
ingredient hidden,
Yeah,
so they can just make the recipe, but not with the wow elements in it.
exactly, exactly. So it's not always possible, but when it's possible, it's very good because you get the advantage of a patent and as a trade secret also.
So that's great. But then the transitions that happen from being a scientist works on very individualistic, presumably a problem with few collaboration, suddenly to jumping to the level where you seek partnerships and you seek the like you are investigating the bigger picture for the business. What was the most challenging part when you did this transition in your career from scientist to a patent attorney and strategist?
Yeah, I think the challenging part is probably to to come back to school again for people because I mean you spend I don't know 8 years in the university, for example, to get the PhD, and your life is evolving. I mean, you met a girl or a boy, and I mean you have a girlfriend or boyfriend, and you have started a family, for example, and then you decide to switch. Okay, that's good, but you need a legal background. So you need to come back to school to learn law, to learn IP law, and of course you have to do that and to pass some exams also to some qualification, French, for example, in my case, and European, which are very, very tough. I must say, very, very tough. And you have to do that at the same time that you have already a family, for example, or I mean, you are not anymore a student. You are working in an IP law firm, and at the same time, you have to come back to school, to learn things, study. You have some homeworks to do, and so on. So I think the challenging part is mainly that. But you have that in several other disciplines. I mean, as soon as you want to switch and in another field, you need in a way to come back to school, and you maybe not have the same age to do it. So this is, I think, the challenging part, because otherwise, I mean, law. Of course, you need to understand how law works, but I mean, come on, when you understand quantum physics, I think you are able to understand more or less anything, more or less, I would say.
Yeah,
But it depends of people, of course, but yeah.
yeah, of course, like linking all facts and getting the logic behind quantum physics
Yes,
with
and the
the
ability
logic
also
behind the
to
law.
yes, and the ability to go deeper and to try to learn things. Because, for example, I have work. My work as a patent attorney has not always been about quantum physics and quantum computing and so on. No, it's, I mean, I have made mechanics, I have made electronics, I have made transistors, I have made doors for houses, I have made intelligent cars, I have made artificial intelligence stuff. I mean, and each time you need to understand the invention, you need to be able to explain it correctly. So in a way, you need to learn. So you need to have a good, great test for learning new stuff each day, more or less.
I see. That's really interesting to know. So then, when you made that transition and you already are in the new field of being patent attorney at this time, what was your first job, if you are allowed to talk about it, or maybe give
Yeah,
a
no, don't
general
worry.
story?
Honestly, the job is the same before. I mean, when you start as a trainee patent attorney, what you do is a job of a patent attorney supervised by a patent attorney. So you do the job and the patent
Yes.
attorney will review it and will say, okay, that's it's good. No, you can have to change that, blah, blah, blah. And and depending on your supervisor in a way, sometimes it's just, oh yeah, it's good. And sometimes you get 10 pages of notes on things that you have to change or modify and so on. So the job doesn't really change, I would say. The only thing that changed maybe when you can become a patent attorney is that you get a little bit more of freedom because of course you don't have to meet all the clients with your mentor each time and so on. So you start doing things by yourself. So this is what the change really happened. It's about that. But more or less the work is the same. So now, if you want to talk about memorable cases, yes, I have some of them, of course, but I have always more or less so I have worked on anything about, unless chemistry and biology. because in this IP law firm there was people for that. So I was not touching about this kind of invention, but everything else I did it. So for example, I did even recipe for a hamburger, which is normally not possible.
Oh, wow.
Yeah,
Wow.
of course, you for everyone listening, you cannot patent a recipe. Normally, you cannot.
But yeah, for me, it's something new to patent a recipe for. Yeah.
Yeah, but it was, I can talk about it. It was a panis burger. Panis is a kind of a bread made based on corn. Okay, and the idea of the client, he has a restaurant and he has a specific recipe to make this bread, and so it's without gluten and it's healthy and blah blah blah, and its recipe was able to make bread that will support the full hamburger, which is not easy with this kind of bread. So, I mean, an invention is a technical solution to a technical problem. So I decided to understand how it works to make a bread, the reaction, chemical reaction with the different elements and so on, and what happens when you will cook it, depending on how you will cook it and so on. What is the mechanical effect in a way on the bread itself? And the problem, technical problem, was of course in the manufacturing of bread like that. How will you reduce the loss of breaking breads?
Oh, I see.
So it's a technical problem, and the technical solution was a specific recipe with a specific process of heating and cooking it, and so we get this patent. So that's the funny part, and of course I was invited to eat this hamburger. So
wow. That's the biggest reward ever.
Yeah. Another one which is funny was about a cigar. It was about a new way to make a cigar, and so very interesting also to learn how a cigar is made, how and so on. So very interesting. Another case was very interesting. It was in a company that was designing transistors, and they had a competitor, and the patent of this competitor was very a big pain for them, because they wanted to do exactly the same, but of course they didn't want to infringe this patent of this competitor. So we worked very closely with the R&D team to design a new way, a new transistor that is not exactly what is protected by the competitor, but do the same, and at the same time is new and inventive regarding what exists. So it was great because they get a new product and a patent, because it was patentable as well. And so it was very memorable stuff. And of course, opposition. This is something that we have in Europe. When you file a patent application in front of the European Patent Office, when the patent is granted, during 9 months, anyone can come and challenge it. And of course, one of our clients had wanted to destroy a patent of a competitor. So we went to La Haye in Netherlands, and we make a case and we explain why it was not patentable, blah blah blah, and the guy in front was explaining why it's patentable, blah blah blah, in front of a jury, and we win, of course. And so it was, it was great. It's the cherry on the cake, because when you draft a patent application, again, it's very strategic, because you cannot add anything inside the document when it's filed. So during the prosecution and during this opposition phase, for example, you cannot add anything which is not already inside the patent application. So you need to prepare in a way in advance everything that could happen. So you need to prepare stuff that, like a weapon, you need to prepare weapons inside your patent application to be able to defend yourself if an opposition is raised against you, or to defend the patentability and so on. So it's it's very nice when you draft it and then you need to defend it.
Yeah, I see. So that's really.
But I prefer attack. I prefer the attack of competition.
Yeah, and so now you get the reward of testing the invention and smoking the invention as well.
Exactly.
And be armed to attack and
Yeah.
expect the future moves of the competitors so you can just defeat them by having a perfect patent filed.
Yeah, and you know, I love invention. I love intellectual property because, in a way, it's magic. It's thanks to law, it's a way to transform something which is completely in your mind, it's an idea, into something that has a real value for the market, for a bank, for investors, for, I mean, it's amazing. You come from something in your mind, completely away from reality, in a way, in a sense, and then you get a patent, and this patent has a value. And it has a real impact on the business, on the economy, and on life of people. It depends on the invention. So it's amazing, intellectual property. It's very, very amazing. And because I love invention and innovation, as soon as I can, each time I can, I go to the lab with my clients. I go to the manufacturing. I go to the facilities to just to see the invention, to see everything. I mean, this is the good part of what I do. It's not just about designing strategy and managing IP and so on. It's also meeting people, meeting inventors, talking with them, challenging them also, helping them sometimes, bringing some new ideas. So many times my clients said, yeah, thanks for this idea. It was great. And we make it and it works very well, blah, blah, blah. Because at one point when you are inside all this innovation world, you get ideas also, and you share it with clients to help them, and so it's a very synergy. It's a real beautiful synergy.
And it's win-win situation. You also, the client benefits from you. You have a fresh mind. You think from a strategic point of view, and also, you benefit from them in a way or another.
Exactly, and being an outsource IP manager is very powerful for companies because I can say things that people inside the company cannot say. You see?
Yeah.
Because you're big boss.
Fear authority.
Yeah. I can come and say, no, this is bullshit. No, this will not work. No, I don't think this is a good idea. Or yes, it's a great idea. Come on, yes. And you see? And I can do that because I'm not in the company. So that's why I think, and of course, for some budget reason, it's very interesting for companies to work with outsource IP manager and IP strategist. There's not a lot of them, I must admit, because it's, again, to be a patent attorney, you need just to have a background in law and science. You don't have to need a background in business or management or anything else. So a patent attorney, to become an IP manager, it's not something really easy. So I have, in my case, a Master 2 in IP law and management. So it helps a lot also. And I have learned IP in this way. So more than 10 years ago, I was already starting my life as an IP strategist in a way. But it's very, very useful and powerful for companies. Otherwise, they don't have a real design strategy. They just file patents because the competition is filing patents. So we must file patents. They don't really think about trade secrets. They don't really know what it is. At least in Europe. In the US, they know it very well. I mean, intellectual property in the US is very, very, very well known, understood by people. In Europe, it's very more complicated. And it's very important. That's why I do my newsletter or workshops or events and so on to bring awareness to founders, companies, small and big, about why a strategy is so important about IP, and the correct management is very, very crucial. Otherwise, you are just losing money.
That's really, I would say, a very, very important point because the notion of IP differs from the United States. Of course, they have a different cultures about the trade secrets, and also they are good in business. I have also graduated from an American-based education, and all the time you get a good courses in business in a way that's different from the kind of education in Europe. And this brings me to this question. What are the key differences between the IP laws in the United States and in Europe, and how they differ from one another?
There's a huge difference, but so of course in copyright law, in trade secrets, there is some kind of international I'm losing my words today. There is some kind of international decision to kind of everyone is okay more or less with about trade secret and so on. But clearly, for example, from a patent point of view, there is huge differences. Less and less, but still. For example, before 2013, you could file a patent in the US for kind of any business idea you have, a business method. For example, the one click of Amazon, it was a patent. I mean, the ability to say on one click, I pay and I put the product into the cart and I pay it directly and it will be delivered to me, only all of that with one click. And it was a patent. Today, it was not possible to get. It's not possible to get a patent like that because the law has evolved. And in Europe, for example, they are very strict. A patent is a technical solution to a technical problem. This is the definition. And they have a very guidelines to explain how to understand an invention, if it's a patentable or not. And it's, for example, in software, a lot of people think that software is not patentable. Yes, as it is, software is not patentable, but a software is what? It's a process, a method with several steps. So if it's a method that solves a technical problem, it's potentially a patent. You see?
Yeah, because there's Amazon, the clicking on a button in Amazon, that's a software
That's
solution.
a software, yes, but it's not technical. I mean, so in Europe, it will not pass. But in the US, it was good. It was okay. But in 2013, there was a case, Alice versus another company, Bank of America or something like that. And of course, in the US, you know that it's a common law. So it's changed a lot. So when there is a decision, it will impact the way of dealing with future decision. So in this decision, it was decided that okay, business method is not really patentable as it is, and you need kind of more technical effect and so on. So it was a decision in the direction of the European philosophy in a way. But still, there is a huge differences. In Europe, you need to be very technical. In the US, you can be less technical. The way you draft also is patent application. And for example, I have learned how to draft in the US because I work a lot with North America, Canada, and the US. And so when I draft a patent, for example, from one of my clients in Europe, I always ask, do you think you will go to the US? Most of the time, they say yes, of course. So I will draft the patent application. It's a hybrid version of an European patent application and a US patent application. The idea is to be able to have something already ready to be filed in the US without too much modification. For example, it's very basic, but in Europe, they want to have some numerical references within the claims. In the US, they don't want. You see? And there is some other differences like that. So yeah, being able to draft a patent application that works in the US and in Europe, it's already something very interesting for clients, for sure.
But then, by technical solution in the European culture, does it require a hardware involvement?
Exactly.
Sort of,
yes.
or
Yes. Exactly.
No,
exactly.
So
that's why, for example, you will say that this step is made by this module that designed to do blah, 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 blah. And this step is made like this module, blah, blah, blah. And in the US, for example, you can avoid to talk about the module. You see, this is the main difference if you want to talk about software invention. In Europe, you need to bring the hardware part inside the claim. So the claim is what design the protection that you are looking for. For people that are listening to us. And in the US, you don't need to bring the hardware part. So it's one of the difference, yes.
So they can patent a full working software solution without the requirement of involvement of any hardware whatsoever. So
there is always hardware involved, of course, but you don't need to explain them directly in the claim.
I see, right.
But you have always, of course, software, hardware part,
hardware part. So now if this patent of Amazon is filed again at 2024, it won't pass in the United States.
Exactly.
Because Yeah, I see.
I mean, probably. Again, it's because it's a human decision in a way. I mean,
Yes,
you
yeah.
have a patent examiner that will examine the patent application and decide if it's, it will, of course, explain why it's patentable or not. It will have to find documents trying to challenge the novelty and inventiveness of the patent with prior arts document. But at one point, if he find nothing and he say, okay, it's patentable, that's it. That's why also there is this opposition part in Europe, and a patent can be challenged anytime in his life. At any time, you can go to the judge and say this patent is not valid, and I want to challenge it. And you bring a case and you explain blah blah blah. So that's why I mean a lot of patents are granted, but could be challenged. You see.
Yeah,
but
right.
again,
Yes.
it's, I mean, if you spend 1 month trying to destroy a patent, you will probably find a way at least to restrict its scope of protection. But of course, patent examiner cannot spend 1 month only on one patent application. And that brings me something else about quantum, for example. We are facing kind of a situation right now because, of course, patent offices don't have quantum physicists to assess quantum patent application. It's logical. I mean, we don't have, as far as I know, in Europe, we are mainly between probably 5 to 10 PhD in quantum physics being patent attorney. So it's very few. And in Europe, European patent attorney, we are something like 13,000. So more or less 10 people are just patent attorney and quantum physicist at the same time. So of course you can imagine that a patent examiner, there is basically no patent examiner with a PhD in quantum physics. And then you will ask them, so you will ask people with a degree, I don't know, in computer science, for example, to assess the patentability of a quantum computing invention. And so far it's very challenging because when you draft the patent application, you need to be kind of teaching, in a way, things. You need to explain what is a qubit, for example, what is entanglement, what is blah, blah, blah. And you need to explain all these elements to be sure that the patent examiner reading it will understand the invention, how it works, and so on. We had this problem before. It was kind of less present, but we had it about artificial intelligence. When we were going deep into AI, not just about, oh, I am doing stuff and I am using AI to do it. No, I mean, when you are designing an artificial intelligence, and the patent is about that, for example, with genetic algorithms and so on, we had this kind of issue sometimes with patent examiner that was not exactly on the same page with the invention to understand it clearly. So the document that was cited was not exactly in the same field or was not talking about the same thing, stuff like that. So sometimes the clients say, I don't understand. It's completely different. And yes, of course, but he has made what it was possible for him to do. I mean, and so in quantum physics, it's a bit this situation right now, mainly in quantum computing, because we file patent application for very complex system. So you need to be able to understand all this system, how it works, and so on. It's very challenging, I think, for a patent examiner without background in quantum physics. So yeah. I do my best when I work with companies and quantum companies to bring as much as possible knowledge, quantum knowledge inside the patent to help to understand it and to make sure that everything is clear.
Yeah, that's an interesting point because this was one of the questions. I mean, I hear also all the time because we see a lot of emerging technologies in AI, quantum computing, and so on, and there is a race to patent everything. But then, how to judge what is patentable and what is not, and for example, how this patent committee would assess these new components, especially, for example, as you said, this genetic algorithms, or for example, generative AI is we have a model, we have an algorithm, we have the software part, but also have the data that are involved to extract these coefficients in the model, and there might be these coefficients or these weighting factors or this optimization numbers that are the ones that should be patented. So how do you look at this if from your perspective? I mean, can you give, for example, an example of a patent of an AI and explain the challenges that sort of around it?
Yeah, the challenges is to comply with what a patent office is waiting to see inside the patent application about AI. You need, there is some guidelines now, so it's easier than before. And you need to be sure that you will explain everything. Sometimes since you are talking about training data, you need to explain where come from the training data, how it has been made, the data set, and so on. And to talk about what is patentable or not, I mean, again, if it's a technical solution to a technical problem, it's patentable, at least as an invention. No, the question remains about novelty and inventiveness. But the main question I start with my clients, it's why do you want to patent this? What for your business, is it useful or not? Will be using, I mean, what in your business strategy this patent will bring to you? And of course, when I start working with a company, the answer is I don't know. And when I work with a company for a few months or a few years, the answer is it will help us with this project, for example, because they spending time with me make them thinking more or less strategy.
So that added value.
So they start, exactly. My idea is not to spend all my life with the same clients. It's to help them to understand things, to help them to do things by themselves at one point, especially in management and strategy. I mean, some of my clients have in-house patent attorney to draft patent application, but they don't have the strategy or the management part. So this is what I bring. But yeah, the main question is why? Is it useful or not? And sometimes it's just say it's not useful as a business point of view, but regarding the competition, we want to make to take a stand. We want to say we are in this field also. You see, so sometimes it's not a powerful patent, or sometimes it's also what I call a marketing patent. So it's just to say I have a patent on that, and that's it. We know that it's not very strong, but at least for a communication point of view, for a marketing point of view, it's good for the client to say I have a patent pending, patent application pending.
Yeah, but then now because of this, the evolution that happens in generative AI, and we see, of course, the success behind OpenAI and the ChatGPT that's now embedded in most of businesses. I mean, in copy editing and writing and grammar checking and even automating writing articles and so on. So we see also some emerging startups, without naming anyone in Europe, that want to mimic or emulate the kind of architecture behind OpenAI. Would this be patented in under the European umbrella, or what? How do you see? If someone wants to reinvent OpenAI again.
I mean, if the way to do it is different, yes, why not? I mean, we have to keep in mind that more than 53% of the European patent application last year was about software invention. You see, so software invention is huge. It's 53% of all the patents filed in Europe last year. So for sure, first. Then AI, of course. And again, if you find a new way to make a ChatGPT work, a new model, a new transformer, for example. I have worked with companies that design new transformers, and we file patent application about that. Sure, you can get a patent on that. And you can reinvent, in a way, ChatGPT if you make it faster, smaller. For example, multiverse computing with this last product is able to reduce the size of a model and to keep the quality of the model. This is amazing. So this kind of technologies, of course, is patentable.
Yeah, that's interesting, because also they have released a paper about it, and this also brings me to this interesting point, because now there is like ongoing interest in open source, and of course journals and the magazines and all of these scientific publications, they want to open source software to be dominant. And you mentioned also very interesting comment that even if it is an open source and if it's open source material, it could be patented and be used in commercial basis. So
yes,
how do
the
you see
idea,
this?
yes, the idea of a patent is a intellectual property right. So we forget the intellectual, and it's a property right, like a house. You have a house, you can, if you want, rent it, right? So now, of course, it's not a house, it's an intellectual property right. So you can rent it in the US, you can sell it in China, you can keep it for yourself in Europe, you can do whatever you want. And you can also, for example, say in a license agreement, it's an open source only for some application. For any kind of other application, it's not open source and you need to get a license from me and so on. So a paid license, of course. So for example, imagine it's just an ideal case, but a scientist that designed a new way to make energy, green energy, very perfect green energy, powerful, blah, blah, blah. And it could file a patent and provide a license, a free license for use of this technology to create power plant and energy, blah, 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 for cities, blah. And at the same time, for every military application, it's not in the open source license. So in a way, it can avoid its technology to be used for military purpose. Well, it's an ideal case because it's more complicated than that. But the idea is to say that I have a technology, because I have a patent, I am able to control the way it will be used, for why and where. If I don't have a patent and I just get it I share it on open source directly, I cannot control anything.
Right, because it's open now to the
Yes, and the main issue that that I think IP has with academic researchers, it's that they are focused on publication, because of course this is the way, this is a metric for them. How many papers have you published this year? You see, it's not how many patents have you filed, because it's not part of the culture in a way, at least in Europe. And so they think more about filing papers than filing patents. And I think this is, it's a bit sad, because sometimes, honestly, I work with labs, and like I have worked with CEA in France, and I have worked with CNRS and so on. And sometimes the guys comes and say, yeah, we have a patent, and I mean, we have an invention, and finally we would like to patent it. Okay, do you have some technical document to share with me to explain me and blah, blah? Yes, we have a publication, here it is. Guys, you know that it has to be new, even regarding what you have published before. So yeah, sometimes it's complicated like that. And sometimes also we have to file the patent in 3 days because there is a publication, or there is a conference or a seminar or something where the invention will be disclosed. So the relationship between IP and academic world is sometimes kind of complex, but I think it's because it's not, I mean, IP is not part of our culture in Europe, at least. In the US, if I'm correct, and if there is a US guy can correct me in the comment section, I think it's in the Declaration of Independence, or I think, but, or maybe no, maybe it's, I don't remember, but in one of these very important texts that that has designed the USA, it's the third or the fourth amendment, maybe, that talk about the right to invention, to intellectual property. I mean, it's very, very important for them. In Europe, I don't think we have probably in a text somewhere that say that. We have, of course, in France, a full law text about intellectual property, but it's not in the DNA directly of the country, you see, innovation and protecting the innovation with IP. Because again, a lot of, when I change from academic to private law firm, some of my friends, they said, why do you go in this? It's just about money, it's not about sharing knowledge and so on, but it's not true, because thanks to IP, knowledge is shared. Otherwise, it would not be shared. Because if you think that a patent does not exist, as an inventor, what do? You keep it secret. You keep it secret. Why? Because you don't want someone else to steal your idea. So you keep it secret. You don't share it with someone else. And when you die, the technology dies with you in a way. Okay, simple way, but yeah, why not? Yeah. But thanks to IP, when you file a patent application, for example, in 18 months, it will be published to everyone on Earth. Anyone on Earth can read it, understand it, learn from it, and start making a new invention from that. So just during 18 months, it's kept secret in a way. But you can, if you want, publish it on a scientific paper. It's up to you. But I mean, it's an obligation for the patent to be published. Unless you said, no, I want to remove my patent application before the publication. It's removed. You don't get a patent. Nobody is aware of what happened. But if you want to get a patent, you have to disclose your technology. You have to disclose it enough to be reproducible. And this is very important. A patent is a contract between a state and an inventor, saying, I will grant you the exclusivity to do it, but in exchange, you need to explain how you do it to allow anyone to work on that and to create something new. You see? So it's again, it's very, very important. But again, it's not I mean, there is no teaching about IP like that at school or at the university. I mean, even me, I never had any course about IP in the university.
Yeah, that's a very interesting point that you explained now, and also the philosophy behind the patent. Because, for example, in our university, I mean the PhD university, where I'm pursuing my PhD, we also have learned about the IP. But of course, you see other colleagues maybe in a theoretical field, most of things goes in open source and so on. But then you go for biosystems or folks who are working in biological fields. If they synthesize a new molecule or a new compound, that's patented for sure.
Yeah.
And of course, once an investor hears that there is an IP, regardless of the application or how it would be coupled, that would mean that direct investment at all. But we have never, maybe I didn't see it explicitly, that also the IP is a way that you know or you learn about what others are doing, and then you still, of course, you cannot use this patent directly without, of course, like pre-authorization with the owner, but at least you know that this application do exist.
Yeah, but you can use it. I mean, it's very important. You cannot use, if a patent has been granted, let's say in Europe, in France, let's say in France.
Yes.
You will be able to do it for your own, for your personal use. You can do it. It's not a problem at all. You can do it. You cannot. Yeah, exactly. You cannot make money with it. That's the main idea. Many ideas you cannot make money with it, but you can make it for yourself. You can make it for R&D purpose. So you can have an R&D team doing it and starting to work on that, trying to improve it, trying to make new things from that. So it's very important that it's not only that you cannot do it. It's you cannot make money with it. So your R&D team can work on a patent of a competitor, reproduce the same product just for R&D purpose, and try to change it, improve it, optimize it, and so on. So it's it's very powerful.
Yeah, that's also a very powerful point, because you hear all the time. I mean, at least I hear, you know this already because you are a specialist in the domain, that Tesla releases all of these patents and make them public. But again, if presumably now, as I understand, if they make it publicly accessible, it doesn't mean that other companies can use it for profit. Just only
exactly.
Yes.
If it's not on an open source basis or a free license, I would say, I mean, it's just marketing. I mean, Elon Musk said at one time, no, IP is not a patent. Is not important. I mean, he was saying, I think patent is for the weak. Yeah.
Yes.
Yeah. But
what do you think about this?
Yeah. But it's quite simple. What he was saying, it was not what he was doing, because Tesla was finding a lot of patent application, a lot.
Yes. Yeah.
So it's just marketing stuff. You see?
Yeah.
It's always do what I say, not what I do, more or less.
Yeah.
And yeah, I mean, IP again is very beautiful. It's not something about making money. It's really something about putting value on the brain juice of someone or a team. I mean, I have seen inventors working for years on something to come up with an invention, and it would be sad if anyone could just store it like that. You see, so it's again IP. I'm not a naive person, but I like to see the bright side of patent and IP. Okay, of course you can do dirty things in IP as well, but I'm not interested in that. But IP is really something very beautiful because it brings protection to the brain juice of people. I mean, it protects even with copyright. You're designing you are painting, you are drawing, you are making a photo. I mean, being able to have a protection of what you have created, it's on personal feelings, it's very important. And it helps you to create more, you see? Because if a genius creates something and it's stolen, it will not be really okay to make a new invention. But if it's okay because it's protected, he gets money for that, blah, 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 yeah, I mean, it will do another one, and the society will be improved by that.
And the recognition also as well for the credit and the mention. And
exactly.
Yeah, that's really interesting. And this brings me now to the quantum computing era. Everyone is racing for a patent, despite the fact it might work, it might not. I mean, how do you navigate this quantum computing race of IPs at the moment? How do you see it?
Yeah, so several things. First, as far as I know, I am the only one outsource quantum IP manager and strategist. Because again, of what we have said about quantum guys in the IP world, we are not allowed. And if you add that with LLM in IP management and IP law, we are basically, so far as I know, I'm alone. If someone is looking at that and it's not true, please comment. I would be happy to meet you. So because of that, I have the privilege to work with several quantum computing companies. And because quantum computing is so wide. I mean, there is so many ways to do it. And this is great because I love it. I mean, I work with Candela, for example, on photonic qubits. I will work with another company about, it will be an ion trapped, for example, and I will work with, and so on. And it's very interesting because right now, nobody knows exactly what technology will be leading the race. So, and each one of these technologies has some advantages and disadvantages, yeah? So what is very interesting is when you are looking, IP is a window open to the future. Because when you are looking for patent application that has been filed by companies, that means that this technology will be probably used or commercialized in 1, 2, or 3 years. So it's a way to know what will happen in the future. Sorry. So so for example, if you look at the patent application filed by Google, IBM, or other big companies in the quantum field, you know already which will be the trend or not. And I think we are going into, for the quantum communication part, because it's part of quantum computing in a way, we will be going into standardization, like the telecom, 5G, 6G. So we will going into a standardization system, and with patent pools. And patent pools, for example, are very interesting. It's a way to say, we have a big bucket, every player will put its patent inside, and we share it together. And if someone is infringing it, we all come to him. So it's very powerful. It's very well used in telecom and other very important technologies like that. And it's starting to come up in the quantum computing fields as well. So yeah, what I see right now, it's basically each technology, as each company working with a specific technology is creating a patent portfolio to be able to be sure that the core of their product is protected, of course, but also to be able to join forces with others. Because I think we will not go into only one solution at one in 10 years, for example. In 10 years, we will not have only one kind of quantum computer. We will have probably several kinds of technologies used to make quantum computing, depending on what you need exactly, what the resources you need, what are the conditions where you want to apply it, and so on. So it's very also important to collaborate. And IP, again, is a very good tool for collaboration between companies, because I have some patents, you have some patents, I would like be able to use yours, and you want to use mine, so let's cross-license them. And if I don't have patent, it will be very difficult for me, because I will have to pay you to get a license and so on. But if I have some patents, we can work together maybe. And for example, some of my clients, part of the strategy is to design patents, not for their own use, but for the use of competitors, to be able to deal then and to discuss with them and saying, yeah, look, we have these patents, and I know you would like to have it, right? Okay, and I'm interested by this one. Let's cross-license them. You see?
So they can have leverage points and make the negotiation better. Yeah.
Exactly.
Negotiate in better terms. That's great to hear. And now I learn a lot from your newsletter about the art of strategy and what inspires you. What has inspired you to publish such a newsletter? I mean, it's quite active. It's on almost on a regular basis now.
Yeah, it's every week.
And what do you hope from it?
The main idea was I have learned so many things in my life, because I have some big health issues starting at 15. I have a sarcoma when I was 15. I had to optimize my life, the way I work for my studies, the way I work with my memory, the way I work my speed reading. I have improved my health, my nutrition, my diet, so many things. And each time, because my wife is kind of a copy paste of me in a female based, I would say. So we don't have TV at home. We spend a lot of time readings and going into, we like to go deep into things and to understand them, and because you can read everything. Right? If you take the diet part, for example, you can read everything on the internet. It would be good, not good. For the same thing, could be worst or best. I mean, it's very complicated. So understanding how everything works in every aspect of life is very interesting. And this is what I have done for several years now. So at one point, I want to share things with people. So the art of strategy is because everything I have done in my life was based on strategy. And I think it's very important, because everyone has a strategy. Everyone. It's a good one or it's a bad one. You see, I mean, people think that you need a diet strategy to lose weight, but you have already a strategy. Maybe a bad one to get more weight, but it's a strategy. I mean,
indeed. All life is about strategy now, as I see from our conversation.
Exactly. So strategy is just a way to transform a dream into a goal, because you make a plan. And I really love this sentence that say, if you fail to plan, you are planning to fail. And this is exactly that. So this newsletter is mainly, of course, about IP, because for me, IP is very important in life. And it's about also optimization of the brain, because I have also a diploma in neuroscience. So because I wanted to be, again, if you want to improve your life, because you see your life and you feel it because of your brain, the first things to improve is your brain. Then you will be able to improve everything else. But you need to start with the brain. So I wanted to study the brain, and neuroscience is very, very powerful. And right now, there are so many things you can learn with neuroscience. So in this newsletter, I push a lot about IP, about quantum, but also about Mind Palace, improving memory. I think I will make one about speed reading, very, very powerful. Mind mapping also. This is the tools that I would love to have when I was a kid. You see, because when I was a kid, I didn't really like to read papers or to read books because I didn't know, I was not aware of speed reading. So for me, it was kind of boring, you see. So only books like Stephen Hawking's and so on, I was, yes, reading them. But otherwise, it was difficult. When I discovered speed reading, it changed everything. Because I was able to enjoy what I was reading because I was reading fast and my brain was happy with that. And mind mapping, very powerful also to be able to connect ideas, create new ideas and so on. And of course, memory palace is very powerful because the mind palace, it's a way to be able to remember everything you want. So these are the free tools, very important. So it's part of my newsletter. I'm talking about strategic thinking also, effective theory. I mean, everything that can, I hope, bring value to the readers on a business point of view, on a personal point of view, sometimes a bit less. It's more on Sunday. Most of the time I post because I post every day, and every day is a specific topic each week. Because again, it's strategy that I have designed for LinkedIn. So on Sunday, it's more about personal stuff, about how to go into the flow state, sorry, how to reduce the stress, for example. And I'm trying things also. So I like to share what I have tried, what works, what doesn't work. Yeah, I mean, if I can improve the life of people, I'm happy with that. On a business point of view or personal point of view, I mean, it's
yeah, thanks for this, and I think it's very quite beneficial to have these newsletters. I'm learning from them, and I believe there is a lot of readers are learning from it as well.
Honestly, I'm very impressed. We are more than 4,600 people right now. And
wow.
I'm amazed because the numbers keep going up. And I mean, I was not I was not prepared for such a number, you know. I was thinking that, okay, I will get people maybe in the IP field but no, when I'm looking what kind of people is the subscribers are, I mean, in every side of the world, any side of works, backgrounds, and yeah, so I'm very touched by that and motivated. I mean, it's very challenging to be able to write an article each week, especially because I avoid very short articles. I want to bring value. Sometimes it's a bit too long, I think, but I mean, I think that people can, if they don't want to read everything, they can just pass if they want. But at least everything is here, and if someone can use it and get value from it, I'm happy with that.
Yeah, this is something impressive, I would say, and yeah, I hope that you keep doing it with the same energy and all of your like fan base to increase as well. And this is now brings me to the last question. I don't want to keep you long. What do you wish for the future of IP and patent laws in Europe to take place?
I wish that I wish for an increasement of the awareness of IP among people. I would love to have IP teach at school. It would be great just to have a small idea of IP. It exists. It's okay. Somewhere you know that if you have an idea, maybe you can protect it. And then if you're interested in it, you can go and learn more about it, but at least just a glimpse of that. I think it would be great. For the future of IP, I have an article about that. It was a glimpse into the future, 10 years in the future, about the use of AI in the IP world, of course, because my company is also designing AI tools for IP practitioners. So yeah, what I wish is that IP practitioners become business partners. That at one point, to become a patent attorney, you need a background in business as well, not just law and science, because this is really what will be important in the future. I mean, I have already tools that can draft patent application basically alone, more or less. Of course, you review it, but right now my tools are like trainee patent attorney. They can do the work I was able to do 10 years ago, and then I just go behind and just, okay, I correct some things and blah, 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 and that's it, that's done. And for strategy as well, I have something, and every task as a patent attorney or IP manager or IP strategist, we have designed more or less a tool. So that means that in 10 years, AI will be so more powerful that what I will be doing? I mean, what will be my job? So my job will be talking with people, understanding them, understanding the needs and the business and how to use IP for the business to support the business goals. And this AI will not be able to do it yet. So what I wish for the IP in the future, it's to more awareness about it, more business involvement. Really, not because right now in a big company, for example, IP is in the legal department sometimes, or in the R&D department. I mean, even the fact that you don't really know where to put it means there is an issue on the understanding of IP, what it is, what it can be doing in a company, and so on. So I wish for more awareness, understanding of IP, and for the IP law in Europe and so on. I mean, I don't see any modification, but it's more, again, it's really awareness. I think it's very important, even for investors. For example, I have designed an IP due diligence approach, very specific way to do a due diligence of a company, mainly based on IP because it's connected to every operation within the company and so on. And IP never lies, by the way. So it's very powerful for investors, but because a lot of investors don't look at IP. They don't just ask, do you have a patent? Yes. Okay. And that's it. They don't look if the patent is correlated with what the company is doing, if it's a granted patent, if it will be granted or not, what are the chains and so on. So many things. And when you know that 60 to 70% of the value of a company is based on IP, I mean, you cannot avoid checking IP. And again, it's a lack of awareness because, again, people, at least in Europe, are not aware enough about IP. And otherwise, I mean, the European Patent Office is doing a very great job. We have now the unitary patent court. So it's a new evolution and very interesting also. So I don't wish for any low evolution, I would say. It would be great, of course, if all the countries of the world was okay with the same guidelines and so on. But we will talk about that maybe in 50 years or 100 years, but not before. So yeah, more awareness, and I think more business involvement from IP practitioners, because this will be the way to survive with the AI coming.
And this is a very good point because a lot of jobs might be diminished because of AI. In particular, things that are related to filing or doing some kind of automated tasks. But as you said, being an IP practitioner or that will bring more value if they are a partner to the business, and so they learn more and they can do more than just only filing or filling forms for that. So that's really interesting. Thanks very much, Benjamin, for being here today.
I can spend hours talking with you.
That is the same. I mean, I really learned a lot from our conversation. It was quite pleasant, quite informative, and I'm pretty sure that everyone who will listen to this podcast would learn a lot about it because it's very powerful. It has a lot of knowledge. It brings down what the IP is about, how to get it, and a lot of useful key messages for startups and the companies about the philosophy of IP, and that's it. So thanks very much for accepting to be a guest on the podcast, and we will meet in the future, and I will keep reading the newsletter as soon as they are published every week.
Thank you very much. Thank you very much, and it's an honor really to be here, and to share all of that with you and your audience. It's a pleasure, really.
Yeah,
I come back whenever you want.
Yeah, thanks very much. I'm pretty sure we'll have a lot of future episodes about this. It is very interesting, ongoing subject.
Yes, thank you very much.